No, no, no. I say no. We postpone. Thursday. Go to the corner of the Christmas vacation. The problem.
Maybe Thursday. Please allow me to mention hearing item 17 on behalf of Sor Ali Sheikh. For this instruction, I feel the Supreme Court to list the matter on 12th June.
Item 17, yes, what you want to submit?
Yes, my lord. Item 17, hearing item.
Yes, want an adjournment here.
Yes, yes.
You're
If it's on
appealing
that
for
was-
the petitioner. On
For
behalf
a
of-
petitioner, my lord.
Who is your senior and case counsel? And case-
Sor Ali Sheikh, on behalf of Sor Ali Sheikh. On his prayer
Sor Ali Sheikh.
instruction. I pray the matter be listed on 12th June. As he is outstation, lawyer.
Lordship, there are a lot of cases on 12th June.
Pardon?
Lot of fixed cases on 12th June.
Don't fix it. With 12, we have already fixed matters,
Yes, Lordship.
lots of matters, I don't know. Try to get another date when it can be.
Probably next week.
19th June, maybe 19th.
Can it be on 19 June?
19th.
At a request made by the counsel for the petition, appearing on behalf of Mr. Sohar Ali Sheikh, matter is adjourned. Is accordingly on 19 June.
I would like to.
Wait, please, Your Lordship. Lordship, may I beg to mention item 18 and 19? Here, the earlier advocate counsel, they have withdrawn their vakalatnama. And yesterday only I filed my NOC and vakalatnama. So the matter may be fixed on 27 May as a fixed matter.
27.
Yes.
27 is yours? 27 is Monday,
Tuesday.
Tuesday,
Yes.
body matters.
Yes, yes.
At a request made by the counsel for the petition, stating that he appeared in this case after withdrawal of the vakalatnama by the earlier counsel. Poster, considering the prayer made by the learned counsel for the petition, is the matter according on 27th.
Yes, Your Honor.
These are all connected matter, both the matters, or separate?
It's a
Out of same FIR or other,
different FIR. Your Honor.
different FIR?
Yes. Development.
Please, Your Lordship. Lordship, I beg to mention item number 2 on behalf of Devika. If 2 weeks time may be granted to me, Lordship. I'm yet to receive the status of the case, Lordship.
May I please, Your Lordship? Your Lordship, let this be the last chance.
Last chances was given. So you have not get the instruction or what you are?
I'm yet to receive the instructions, Lordship.
But the last occasion also, I think there was an order. I have produced the record yesterday night. When the last order is but last order, your submission was recorded that the case of the petitioners is under consideration.
Lordship.
And 3 weeks, accordingly, you paid for 3 weeks. But now again, you are paying time. How many weeks you need for instruction taken?
2 weeks, Lordship. 2 weeks.
2 weeks.
Lordship.
Hard your MS,
Give me ceremony.
hard MS students with the counsel for the petition. And also hard MS Libika,
S. Chang.
S. Chan.
S. Chang.
S. Chan, you are a government advocate.
Lordship.
Of course, government advocate appearing for a respondent submitted that the respondent needs some more time to take instructions from the government. In that context, MS Swenso, the learned counsel for the petitioner, raised objection and submitted that this was considered to be the last chance as per order, as per the last order. However, considering the submission made by learned government advocate, let the matter be listed after 2 weeks, enabling the respondent, state respondent to get the instructions in regards to implementation, in regards to the consideration of the case of the petition.
Much obliged,
Like,
Lordship.
May it please my lord, I beg to mention item 6 to 10. I'm yet to receive instructions. So may I pray that 3 weeks' time may be granted to receive instruction. It's an analogous matter.
6 to 10, all are analogous matters.
Yes, my lord. Even item 4 also. Item 4 and item 6 to 10.
Hard MS Swenso, the counsel appealing for the petitions, And you are appearing for all the petitioners in the item 6 to 10 or
Yes, my lord. Yes.
in all the all the petitioners?
Yes, Lordship.
And also heard your Mr.
LD Sankta,
LD
additional
Sangha,
AG.
Additional AG appearing for the respondent. State respondent submitted that. How many weeks you need now?
3 weeks time may be granted.
3
my lord.
weeks time may be granted for to take instructions from the authority concerned. Prayer allowed, list the matter accordingly after 3 weeks, enabling the respondent side to take the instruction, proper instruction in this regard. Same order will be there for item number 4 also. Item number 4 who is appearing. Item number 4,
I'm for respondent number
I
4.
guess.
in item number 4, you are appearing for petition. You are appearing for respondent number
4, Lordship.
4.
And for the
It's a
state
private
respondents.
respondent.
Yes, Your Lordship. private respondent.
Khali, 81 difference. Khali, private respondent number 4, she is appearing. That much only different. In that case also you need 3 weeks.
Yes, my lord. Yes, my lord.
No, Your Lordship.
Okay.
Much.
May it please your lordship. Lordship, I beg to mention hearing item 15. Lordship, here I'm for respondent number 1. The principal counsel B. N. Sharma is indisposed if the matter can come up after 3 weeks, Lordship.
Who is representing the insurance company? Is that you are?
Lordship.
And a request made by the learned counsel for the respondent appearing on behalf of Mr. B. N. Sharma for the respondent number 1. The prayer for adjournment is allowed, to which the learned counsel appearing for the appellant raised no objection. List accordingly, how many weeks?
3 weeks, Lordship.
3 weeks.
Lordship.
List accordingly after 3 weeks.
Lordship.
For motion, item number 1.
Lordship, this present contempt petition has been filed against the respondents for willful and deliberate disobedience of this Honorable High Court's judgment and order dated 21/5/2024, passing WPC 76 of 2024. Whereby this court has directed the respondents to induct the petitioners back into their services as Constable GT forthwith and to give notional benefits, including seniority from the date of their initial appointments. Let me take your lordship to the judgment and order dated 21/5/2024, page 12, annexure A.
This was the order passed in WPC 76.
Yes, lordship. Lordship, the operative portion is from page 22, para 18. Considering all the aforesaid aspects and discussions made above, this court is of the view that the impugned orders dated 24/7/2021 and 31/2023, by which the appointments of the petitioners have been cancelled, are unsustainable in law and accordingly set aside. The petitioners accordingly to be inducted back into their services as constables GT forthwith. Lordship, forthwith means immediately or without any delay. Para 19, it is further directed that the petitioners be given notional benefits, including seniority from the date of the initial appointments, but such benefits would not be for any monetary consideration. Accordingly, the writ petition stands allowed. Lordship, the petitioners have also served the forwarding letter dated 3/6/2024, along with a copy of the judgment and order upon all the respondents. However, in respect of the respondent number 5, that is the DIG, the petitioners have personally gone to the group center and submitted the forwarding letter along with the judgment and order. But the respondent number 5, that is the DIG, he refused to accept the same.
To accept the order of the court also,
Yes, Lord, the forwarding letter, yes.
of forwarding it.
Lordship, the forwarding letter is in annexure B, page 23. Lordship, the second para, you are therefore requested to induct the undersigned back in the service as Constable GD forthwith as per the direction of the Honorable High Court, and also to treat this present application as my joining report. Instead of complying with the Honorable Court's judgment order, the petitioners receives a letter from the respondent number 5. That is, Lordship,
Okay, then
and
we'll see to it, everything again, just initially we'll send notices to the respondents, all the respondents.
yes, Lordship.
And do you have any instruction that by that time, is there any steps taken by the contemner respondents? No,
No, Lordship,
as per your instruction, not yet.
not yet.
You are MS,
Churchilla Jamir.
hard MS TJB, the learned counsel for the petition. This consent petition is filed. Under section 11 and 12 of the Contempt of Court Act. Read with Article 215 of Constitution of India. For the willful and deliberate disobedience of the High Court's order. High Court judgment and order dated 21/5/2024. Passed in WPC 76/2022, whereby the respondent were directed to inducted back in their services as constable, and with a further direction to give the benefits of the notional benefits, including the seniority from the date of initial appointment. Post of next para, issue notices to all the resident respondents, contemnants to registered AD and legal process. Please the matter accordingly after 4 weeks. 4 weeks will do.
Oh, Lordship.
For admission, item number 3.
May I please, my lady? Lady, kindly grant me 1 week's time to obtain instruction from the department.
One, there was a note of one judgment of the Honorable Supreme Court.
Yes, yes, yes. So the department is has a proposal if the petitioner is willing to make some arrangement outside of the court. So if a week time maybe grant us so that we can work out. If that is not possible, then yes,
Simply a case of appointment of an
Yes, yes.
arbitrator, I think.
yes, yes.
As per your instruction, is there any proposal for appointment of an arbitrator outside the settlement and all?
In that regard, I'm yet to receive any instruction.
Yes, yes.
You, Mr. Angami.
Yes, sir.
Mr. K. Angami, the learned senior advocate. Appeared on behalf of the state respondents. And accordingly, he submitted it. He needs a 1 week time to file, to take further instructions from the authority concerned. To that, the counsel for the petitioner raised no objection. Please the matter accordingly. After you take 2 weeks, brother, not 1 week, take 2 weeks.
Maybe 1 week.
1 week.
1 week will be
Please
fine.
accordingly
yes.
after 1. Okay.
Bless you.
Item number 5.
May I please, Lordship? Lordship, by order dated 13/5/2025, Lordship.
13, fine.
The Lordship, this honorable court has directed to the petitioner to appear before the IO. And Lordship, and that was fixed on 25
I means, he was
investigating officer.
interim clearance bail was granted.
Lordship. So Lordship, as far as the statement, her statement has been recorded, Lordship. This is the status report. And the relevant portion will be at page number 8, page 8. Last second last page.
Hmm.
And the statement has been recorded under section 180 beneficiary receipt under section 67 NDPS Act of
Hmm.
1985, Lordship. Lordship, from the statement, Lordship, it clearly transpired, Lordship, that the petitioner is the wife of the Washington Pomai, who is one of the accused, Lordship, and who has been arrested and still in the custody, Lordship. Lordship, from the statement, it appears that all along the husband of the petitioner has been using her account number, Lordship, and through her account, all those transactions was made, Lordship, and which the petitioner is not aware, Lordship. That has been clearly mentioned in the statement, Lordship. And in the last paragraph, Lordship, it is also mentioned that after recording of the statement, Robina, the present petitioner, was released on PR bond with a condition to appear before the IO of the cases and when called upon, Lordship. And again, from the statement, it also appears that she have lost her mobile phone and the SIM card also.
No,
Which
one,
was
you're
killed.
saying that her, I mean, her account number was using by her husband, by her husband.
Yes, my lord. Yes, my lord. As far as the statement under section 180 BNSS, Lord.
And her husband is arrested under, it is a commercial quantity matter.
It's a commercial. It's a commercial. It's a commercial, and then from the FSL report examination also, Lordship. It appears that the result
positive days.
is positive. Which we can also be seen in page number 8, Lordship. Result of the FSL examination report. The first line.
Yes, what do you want to submit? Your petitioner is cooperating in the investigation or not?
Yes, my lord, she have appeared before the IO on 20 as per his own direction, and she have given her statement. And my lord, I further submit that she is a housewife. She's a housewife, having 5 children to look after, and she have never involved in such case. She have no other criminal other pending case against her also, but just that her husband have used her account, which he was not aware at all that her husband is involved in the NDPS offense. But the fact is that her husband was arrested from the resident. Prior to her husband arrest, one Abdul Ali was arrested on 23/2/2025, and no material was seized from the possession of her husband also. It's just that based on the statement of the other accused.
Those materials, I mean, contraband was recovered from her house.
No,
No.
from one
House of one
Abdul
Abdul
Ali,
Abdul Ali.
who is a driver of vehicle Scorpio, bearing PS A01 AR2041. So he was arrested from Zatima New Lane Road, the first accused. So based on the other co-accused statement, her husband was arrested, but his wife, the petitioner, have no involvement in such trafficking, illicit trafficking of the drugs, of the illegal drugs. So I pray that this honorable court made her anticipatory bail absolute, as she's willing to cooperate in the investigation also. And I pray this honorable court also consider her family condition. If she is arrested or detained, and there will be no one to look after her 5 children. To my lord, this court may also be taken into consideration.
You're Mr. Pak. You're Mr.
I am Pakinri Sawo, my lord.
First after her, heard Mr. Pakimri Chabo, the learned counsel for the petitioner, and also heard Mr.
Visumomi.
B. Jomo, the learned, your PP,
Lordship.
learned PP, appearing for the state respondent. It is submitted by Mr. Paking Chombo, the counsel for the petitioner, that she is innocent and she is no way involved in the alleged offense. She is staying with her 5 children, and she was not aware that her account number is being used by her husband, her husband, full stop. But he submitted that thing has been recovered from the possession of the present petitioner, and as per the allegation, all the contrabands were recovered from one co-accused, Abdul Ali, who already got arrested in connection with this case. He further submitted that after obtaining the order of interim pre-arrest bail, she already appeared before the IU and cooperated in the investigation. Her statement is also recorded under section 67 DPS by IU, and she is further willing to cooperate in the investigation. She is further ready and willing to cooperate in the further investigation of this case. Next product, Mr. B. Jamu, the learned PP, submitted in this status report of the case has already been received, and wherein from it is seen that the statement of the present accused petitioner has already recorded by the IU, and after recording her statement, she was also allowed to go on PR bond. He further submitted that from the statement recorded from her statement, it is seen that she was not aware about and in that process, she also lost her mobile and SIM card.
Lordship, mobile and SIM card, Lordship,
Mobile
which
and
was
SIM
given by the
card.
government free of cost.
He further submitted that from the statement made by her, it is seen that she is cooperating in the investigation of this case. Next paragraph, considering the submission made by London Council for the both sides, and also considering the case status report and including the statement made by the petitioner vis-a-vis the conduct of the petitioner, I find that her custodial interrogation may not be required for the purpose of investigation. Accordingly, the order of interim pre-arrest bail dated 13/05/2025 is hereby made absolute, with a direction to appear before the IU as and when her cooperation will be needed. Okay, with the above option disposed.
Obliged.
For orders, item number 11.
Five was still awaited. Now, is there any report from the office report? Service on 5, response number 5 was awaited, no?
Yes, Your Lordship.
Whether it is already served? Affidavit in reply has been filed or not yet filed.
No, Your Lordship, I am representing respondent number 1. One only, my lord.
Only one.
Yes, my lord.
Phone number 3 had already filed. I think.
Yes, Your Lordship, I have received affidavit in opposition filed by respondent number 3, Your
Three,
Lordship.
no?
Yes, Your Lordship.
So you are for the 1. 3 has already filed their affidavit in opposition. What about 2 and 4? Is there any affidavit in opposition filed by them also? No.
No, Your Worship.
And 5 is still awaited. You want to?
Yes, Your Worship.
Can it be waited? You don't, do you want to wait till next date of listing or
Your Worship, till next date of listing.
till next date of
Yes,
listing?
Your Worship.
Was there any order for issue of notice to testimony? No.
No, Your Worship.
Okay, then we are waiting it for up to till next date of listing.
Your Worship.
By that time it may served also, or if not, then you made a request for justice service.
Your Worship.
Hard MS, your MS? Hard MS,
S.
Jailang,
Jailang, S. Jailang.
A. Jilang, the learned counsel for the petition. And also heard Mr. N. Angamin, the learned additional easy.
No, senior government advocate.
Senior government advocate representing respondent number 1. But it is seen that from the office note that the affidavit in opposition has already been filed by the respondent number 3. However, the service report for the respondent number 5 is still awaited as reveals from the office note. Let the service be awaited till next date of listing on respondent number 5. You want to file your affidavit of opposition in that case, or you want for submission?
No, Your Lordship, my affidavit may not be necessary,
May not be
may not be
necessary.
necessary.
List the matter accordingly. 2 weeks, let it be after 2
Yes.
weeks. List after 2 weeks. We are listing it after 2 weeks. And
Sure.
other respondents, I don't know whether they have filed their affidavit in opposition or number 1, he is not going to file.
Yes, Your Lordship. I'm
Yes,
deeply
Your
obliged.
Item number 12.
Appears on call for the petitions. However, from the office note, you are appealing.
Yes, what, for state.
Yes. State is,
State is
state is? Sole respondent, sole
can-
respondent is saying what?
yes. Can you grant, can you pass over the matter, my lady? One of my colleagues is handling and now maybe he's outside, so let the matter be listed tomorrow.
Tomorrow we're not, tomorrow you want? You want to list it tomorrow?
Yes, yes.
Can it be?
If it is not inconvenient for my lady, or maybe Monday, Tuesday, is okay.
Maybe on Monday, maybe on Monday,
Yes,
tomorrow or Monday,
Anything will.
Monday or
Yes,
Monday, list on Monday.
bless you.
Monday is 26th, I think. No? Monday is 26th.
Yes, yes, my,
List on 26th. Okay.
Item number 13.
Yes, it is a
May I
family
proceed,
petition.
Lordship? Lordship, I'm here to file the compliance affidavit for the service of notice upon respondent number 2 and 3. So kindly grant me 2 weeks to file the compliance affidavit. I have taken step only yesterday.
So Dusty was allowed.
Yes, Lordship.
So you have not filed
Yes,
the
Lordship.
affidavit. Until done at counsel for a petition. You are Mr. V.
Mr. Kachishi, Lordship.
Huh?
Mr. Kachishi, Lordship.
Phone number. We are on 13 now. Huh? 13.
Yes.
Your name is not reflected here. No? It's in
There,
first
there,
name.
it's there.
Second
Lordship.
name.
Oh, second name. Acha. It will you are. For the petitioner. You have already appeared, no? For the
Yes,
state,
for
state,
state, state is pro forma.
state is pro forma,
Yes.
but you are one, I think. You were made as a party as a one or two? One, I think.
One.
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 Hard Mr. For the learned PP. No? Yeah,
Yes,
as the
yes.
strength of PP for the state response number one. However, it is submitted by Mr. Chisi that the affidavit in regards to the service of notices to respond number 2 entry is yet to be filed. And accordingly, he sought some more time to file their affidavit on the dusty service. List accordingly after 1 week will do.
2 weeks,
After
Lordship.
2 weeks. List accordingly after 2 weeks.
Obliged, Lordship.
Just a second. Mike.
Item number 14.
One I is there. I is for
May I please, Your Lordship? Your Lordship, I've been instructed to appear on behalf of claimant. So 3 weeks may be granted to file vakalatnama and written objection.
why I is for what? I is filed by you
Yes, for
For?
condemnation of delay, Your Lordship.
for condonation.
Yes.
So that has not yet been disposed of, na?
No.
Yes.
So you have already appeared for the claimant.
Yes.
Claimant here are the respondent number,
1.
respondent number 1. Oh, the only claimants are made party here.
Yes.
Okay.
Your Lordship, I also pray that the record may be called for execution case number 1 of 2024.
No, we are not going to call for record and nothing. Let the first matter be heard on the condonation, then only it will be accepted. Otherwise, my appeal is not yet, accepted. No.
Okay, Your Lordship.
If you have any written objection or objection in regards to condoning the delay and all, you can submit. So you have filed your wakalatnama today or not yet?
After 3 weeks, kindly
Your
give 3
wakalatnama
weeks.
you have filed today or not?
No, not yet.
Hard MS, you are Miss MS Kim.
Piana.
Hard MS Kim Piano, the learned counsel for the appellant, public applicant. I do live the one. And also heard MS
Renboni.
Rimboni, who appeared on behalf of the respondent of the claimant. However, she submitted that she needs 3 weeks time to file their wakalatnama as well as objection if any. Let the matter be accordingly listed after 3 weeks. And the respondent are at liberty to file the written objection if any. Okay, we're listing it after 3 weeks. If you have any objection, you can file in regards to condonation of delay.
Much obliged.
For hearing, item number 16.
May I please, Your
Yes.
Lordship.
Yes.
Lordship, this is a very short matter actually. An unnecessary dispute crept into the appointment of the Gaunpura sheep in the village, the petitioner's village, that is Yangzitong. And because of that small misunderstanding, this appointment has been held back in the last 3-4 years. It has been going on like this, Your Lordship. And my Lord, here in this case, to appoint a new GB, the procedure to be followed is that the village council will have to take a decision. And that decision has to be forwarded to the government. And in this case, Your Lordship may kindly turn to the Annexure 7, page 40. May I take Your Lordship to the type copy 40A after page 41. So this is the decision taken by the village on 4/2/2021. Precisely 4 years back, Your Lordship. May I read, my lord? Meeting minutes. On 4th February 2021, we, the Yangzitong Village A and B Council and GBs held meeting in regard with the appointment of Shri Hukheto Yepto Vait, Shri Z. Ihoto Mongzar resigned. The replacement. During meeting, the House discussed and resolved to appoint Shri Hukheto Yepto of Yangzitong Village as GB. And all of them have signed, Your Lordship. All of them signed.
So this was the minutes of the meeting.
Yes, this is the minutes of the meeting, and this is as per the procedure on how the GB is to be appointed. And all these signatories they purportedly withdrew their half of them from the other tribe. There are two tribes. There are two tribes inhabiting this village called Yangzitong village. The petitioner is from Simi tribe, and the respondent, the opposition, the people who are opposing, they are from the Sangtam tribe. These are two brother tribes who are inhabiting the same village. So apparently, there was a firing incident where one person fired blank shots in the air. Nobody was targeted, nobody was harmed. And that person happens to be a cousin of the present petitioner who was due for appointment as the GB in the village. So, my lord, it can be seen from the government's affidavit. The affidavit that was received on 15/4/2024. I don't know when it was filed.
When it was filed?
We received a copy on 15/4/2024, Your Lordship. So the affidavit may have been filed either on 13 or 14 April 2024. Annexure A, page 6. Whether my lord has got the
Affidavit
affidavit
filed
by the state
State.
respondents. Has my lord come to page 6, Annexure A of the government's affidavit, page 6.
Comment is respond number 1, 2, and 3.
Yes, Your Lordship.
1, 2, and 3.
The respondent number 4, they have received dusty service also, but they refused to appear, so it is deemed served, Your Lordship. It has been 3 years since this case has been instituted.
So annexure A, page 6 of.
Yes, Your Lordship. This is the letter written by some of those who have also recommended for the appointment of the present petitioner, Your Lordship. So may I read their letter? The annexure
Yes.
A, page 6. This is letter addressed to the Deputy Commissioner Free Nagaland. Withdrawal of signatures appended for appointment of GB at Yangzitong village in respect of Shri Hukheto Yepto. So, respected sir, with the subject mentioned above, the undersigned GBs of Yangzitong village have the honor to bring forward the following lines in favor of your kind intervention and prompt action, please. That, sir, the undersigned GBs and VCMs has endorsed the recommendation for appointment of Shri Hukheto Yepto as GB at Yangzitong village on 4th February 2021. However, when there were some issues arising for the nomination of head GB, some miscreants fired several rounds of gunshots in and around the village on 27 February 2021 midnight, with a motive to cause injury, attempt to murder the innocent citizens. The incident has traumatized and has created fear psychosis among the small children and peace-loving citizens. On the other hand, as a peace-loving citizens never resorted to any sort of action, but have placed the issue to law enforcing agency to take its own course of action as per the law. But to our dismay, even after the lapse of more than 14 days after the incident, the concerned agency has failed to take any corrective measures nor book the culprit till date. It is to be mentioned that on 25th February 2021 evening, Mr. Akato Yepto, who is the first cousin of Mr. Hokato Yepto, proposing for the appointment of GB, made a phone call to Sri Longrise head GB and threatened that he has arranged 5 members each of Yeptomi clan from 18 villages to attack our village, which actually happened in reality on 27 February 2021, midnight. They are trying to snatch away the rights of the village founding members, using all the might and powers, but the history cannot be rewritten and justice and truth will prevail till last man standing. Therefore, till such time the issue is resolved, we hereby withdrawn the endorsed signature made on 4th February 2021 and may treat as null and void for the appointment of Sri Wakhato as GB Yangzitong village. To pave a way for the peaceful coexistence in the village, the concerned authority may kindly hold the process of appointment till the issue is resolved amicably. So, Your Lordship, here the language is till such time the issue is resolved. So apparently their signature was to be withdrawn till such time the issue is resolved. My Lord will kindly appreciate this, that the so-called Mr. Akato Yepto, whom they have mentioned in the letter of withdrawal, this person was arrested by the Kifri police. He was tried by the trial court in Kifri. No fault could be established against him, and he was acquitted of the charges, which has in fact, has no reason to interfere in this case, Your Lordship. But the same fellow who was arrested and tried, no fault could be established against him, and he was acquitted. So even going by the language used in this withdrawal of their signatures, now that the issue is resolved, the person who was arrested is also acquitted by the trial court. Till now, they are not giving their support for the appointment of the petitioner, in whose favor the village council took a decision, Your Lordship. And the government is also, with all due respect to my learned senior colleague who is appearing for the state is being very weak in this case. In 2019, Your Lordship, I have filed an affidavit also to that effect, an additional affidavit. In 2019, one Sanctum GB died. And for that appointment, they did not even take the signatures of the Simi GBs. But we still did not object because it is their hereditary right. Even for the Simis also, GB-ship is our hereditary right. It comes through bloodline. We did not object. We allowed the appointment to proceed. In our case, it is a unique circumstance where we are sharing the same village council. If not, under a normal practice, we are from different tribes. We have nothing to do with their GB's appointment. They have nothing to do with our GB's appointment. But as a cohesive unit, as a village that has to function.
But the persons who withdrawn their signatures,
Yes, Your Lordship.
they belong to your tribe or?
No, they belong to
to
the Sanctum tribe. So when one of their members died and then a new appointment was made in 2019, we did not object. Though our signatures were not appended, and the decision that the village council must take as a cohesive unit, as one unit, we give recommendation for appointment of either this tribe or that tribe, Simi tribe or Sanctum tribe. No issue. In their case, without taking our signature also, we did not object, and they could appoint the GB without taking our signature. In our case, somebody fired some blind shots in somewhere near the village. Some blind shots were fired in the midnight of 21st February 2021, Your Lordship. 27th, sorry, on 27th February midnight. Now, Your Lordship, on that pretext, they withdrew their signature. And if we have to strictly go into the rule of law, can you challenge your own order? You have given your decision, and the decision, the village council itself is recognized as a court. So whether the court itself can withdraw its own decision, without a reference being made where all parties are represented to a higher authority. And considering all these underlying problems, which are actually not difficult to solve, the state respondents have also have turned blind eyes to the rule of law, and his appointment has been kept pending in the last 4 years, Your Lordship. So basically, that is the issue before Your Lordship. Now, there are some other childish decisions also which does not even deserve the attention of this Honorable Court, but they took another consultative meeting, which is at Annexure C2 of the government's affidavit, Your Lordship. Annexure C2, page 11.
Yes.
It appears even simple common sense eludes the decision making of some village level authorities. And this is also one of the examples, Your Lordship. Page 11. May I read, Your Lordship? Consultative meeting minutes. As per the directive from ADC Sejong, the council chairman held a consultative meeting with Sangtam GBs. So this also only with themselves, without involving us. With Sangtam GB of Yangzitong on 25/11/2022, and during the meeting, the Sangtam GBs of Yangzitong resolved the following resolution. The Sangtam GBs of Yangzitong village reaffirmed its objection against the appointment of Sri Hukhato as GB at Yangzitong village on the following reason. 1. That Sri Hukhato Yaptomi, who is seeking for appointment of GB, has a clear violation of government notification A clause 3, where it is clearly mentioned violation of unfulfillment of the customary practice of clan village. Sri Hukhato and their forefathers were live as Sangtam Mongzar clan, but in the year 2016, Sri Hukhato Yapto and some of his brothers on their own volition has declared themselves as Yaptomi Simi and left the rights of their descendant, therefore cannot be appointed as GB. On this point, Your Lordship, this is a out of context issue that has been brought up. The Seyechung DB's court and Arnato DB's court. The higher authorities involving both the tribes of two subdivisions have decided this issue where the ancestral lineage was researched, and it was found that they actually belong to Simi clan. Now, when two DBs, joint DBs court have decided that issue, instead of challenging that, these Sangtam GBs, without involving the Simi GBs of the same village, can they take this decision, whether it has any bearing, legal bearing that should influence the additional deputy commissioner office, CHU, or any other party? If they feel that they are aggrieved, it is by a higher authority that the decision is already made that the lineage of Hukhato is actually Yaptomi of Simi clan and not Mongzar. Instead of challenging that, whether they can take this decision at the village level, that also by themselves without involving the other tribe. And that the state is fully aware, but they're still banking on this document. So that's why, as I said from the beginning, Your Lordship, with due respect to my learned senior colleague who is appearing for the state, it is unbecoming of a state to even function in this manner, where there is no even respect for the rule of law, and where there is no respect for the joint DB's decision that has already decided that Hukhato Yaptomi or Ihoto Z Mongzar, who resigned from the post, they are all from the Simi clan. That issue is already decided. But I'm just reading out so that my Lord will have a clear picture of whether they have applied any reasonable judicious mind in coming to this decision, and whether the state has done its job in a judicious manner for the appointment of the present petitioner, Your Lordship. Now, number 2, Your Lordship, Sri Hukhato has violated government notification serial number B clause 4 mentioned for disqualification unqualified for appointment of GB who is found to be guilty of moral conduct and activities Sri Hekhote Yapthomi is found to be guilty on moral conduct in the village. With his type of loose character, moral weakness cannot be appointed as GB. Any justification in this regard will be produced as and when required. Now, somebody fired a blank shot in the village. Now they said the petitioner is guilty of moral conduct and activities, convicting a person in the village without any judicial authority, Your Lordship. Then 3, Your Lordship. Sri Hekhote also violates serial number A clause 4 of the government notification, as he and some of his brothers leave behind a legacy, rights of their forefathers, hence forefathers or clan, hence he cannot inherit the customary and traditional rights of his ancestors. It's already a decided issue that he belonged to Simi clan, and the one who refused to become, who refused to accept that he is Simi, that is Ihoto Z Mongzar, who resigned. He resigned from the post only because he refused to be a Simi and he wanted to be Sanctum. And in so many clans, there are shared ancestry, Your Lordship. But in this case, it is already decided that they are from the Simi clan. And I will take Your Lordship to that. But after that decision is taken, just to withdraw their signature of appointing the present petitioner, this decision was again taken. But the government, instead of chastising them, instead of disciplining these lords which are trying to promote unlawful activities, if a response is to be given from the legal point of view, that the state should have taken an action on this decision taken by the Sanctum GBs of the same village. Actually, we do not want any violence as such or someone to be seriously punished also, but at least some disciplining is required when these kind of decisions are taken. But the state, they are relying on the document itself, annexing in their affidavit without disciplining their unruly and unlawful activities going on in the same village, with them being watchful of what is happening. This is what is happening, Your Lordship. Then number 4, on 4th February 2022, where a meeting was called by the ADC Seychung, Sri Akato and Sri Tohovi GB have admitted in front of all the GBs and administration Seychung town that a firing incident on 27th February 2021 was done by them. However, even after admitting this, ADC Seychung did not question the criminals or submit the report to higher authorities when it was before the trial court, which is biased and directly, indirectly supporting or encouraging criminals to do as they wish. Now the firing apparently was done by them. The trial court, Kifri, tried the matter to see whether they actually had the intention to target anyone in the village or victimize any person as they are alleging in their own findings. And this finding also, though it has no legal force whatsoever, has been accepted by the state and is relied upon as a document even in their affidavit. Now, Your Lordship, I may be allowed to take Your Lordship to whether this decision of the village council, not even the village council, the Sanctum GBs, whether this will have any legal force when the issue was already decided by the joint DBs board of Seychung and Arnato. Your Lordship may kindly turn to page 24, Annexure 2 of my writ petition. The translated copy, the English version, is at page 29, Your Lordship. Typed copy. Has my Lord seen the page? Page 29.
Yes.
May I read, Your Lordship? This is Government of Nagaland, Office of the Seychung and Arnotos DB's Joint Court Camp, Yangzitong Village, Council Hall, dated 30/6/2015. They even went to the present petitioner's village, which is inhabited by 2 tribes, that is Sanctum and Simi. This joint DB's court camp was held in the village itself, where these persons whose documents the state is relying upon, they themselves were present there in this case when the joint DB's court camp was held in the village. And this was on 26th and 27th May 2015, as well as on 29 and 30th June 2015. There were continuous 2 days camp 2 times. 2 days camp 2 times in the village itself. May I read, Your Lordship? Appeal by Khehuto GB Yem Sheklan, Yangzitong village, responding Z Ihoto. This is the one who resigned because he lost this case. That's why he resigned. Z Ihoto Head GB Yangzitong village. Settlement order between Yem Sheklan and Yatuli clan. Sri Khehuto GB Yangzitong village and Sri Kahovi GB Katoi village had appealed on 24/11/2014 before ADC Agnato against Sri Z. Ihoto GB for his publication on 23/1/2014 at Nagaland Post renouncing Yapthomi blood, which was incorporated at page 165 of the book Yapthomi Laga. Asukoko means Chronicles of Yapthomi clan, and claimed or adopted Achumi Monzari clan. Monzari clan. Therefore, as empowered by ADC Seychung and ADC Agnato, 2 ADCs were also involved here because the issue is quite sensitive, involving 2 tribes and the identity of whether one is from Simi clan or Sangtam clan. Therefore, as empowered by ADC Seychung and ADC Agnato upon Seychung head GB and Agnato head GB, the joint court of Seychung and Agnato DBs had a court hearing on 26-27 May 2015 and 29 and 30 June 2015. And according to the statements given from both parties, the joint court made the following observations. And Your Lordship, one more thing which my Lord may kindly appreciate. These joint courts has members from both the Simi clan and the Sangtams. The DBs from the Sangtam clan, the Sangtam tribe, and DBs from the Simi tribe. They sat together in this joint camp to decide this issue. 1. Joint statements of Yapthomi clan was given by Sri Wajato, according to which Khetsiche married Pirila. Khetsiche was killed by Yazami villagers when he went to Yazami village. Pirila was living as a widow when she conceived with Yemshir child out of their relationship. Thereafter, Pirila went away to Yazashi village to stay with her brother Yelise, from where she got married to Tsuchoki. Your Lordship, all this will become a very long affair. So may I take Your Lordship to page 30, settlement
Will you
order.
just tell us this meeting was held in 2015, this
Yes, Your Lordship.
GB courts meeting. So what is the relevancy of this meeting
No,
in our present?
So this relevance is because now the other party are saying that according to them, Hukhato is from Sangtam tribe. Hukhato, the present petitioner. But since he has adopted the Simi identity, that's why he cannot become a GB. So I'm,
Earlier he was from Santham tribe.
no, never. That's why since the GB before him was Ihoto, Ihoto, the name is also Simi tribe name, Ihoto, but he wanted to become Sangtam. He's Yapthomi, but he wanted to become Sangtam. He denounced by publishing in the Nagaland Post on 23/1/2014, which I have read in
No,
the
no,
first
your
paragraph.
petitioner is a Simi.
Yes. So, and then he
Now
is,
the allegation against you that you belong to Santham tribe.
yeah, that is one of the main grounds that they are taking. That's why, Your Lordship, the GB post that he is now about to inherit by way of hereditary lineage was earlier held by Ihoto, who denounced the Simi identity and adopted the Sangtam identity. So that is why this case was taken up by the joint DBs. And according to the joint DBs findings, on 29-30 June 2015,
The earlier GB was how he is related with the earlier GB, the petitioner? The petitioner is how related with the earlier GB? He was any
the earlier GB,
Huh?
they are from the same clan. They are relatives.
relatives?
They are relatives. But because the one who was holding the head GB post, Ihoto, he denounced the Simi identity and he accepted the Sangtam identity. That is the reason why this joint DBs sitting was required to trace into the paternal lineage of where Ihoto came from, whether he is from Yapthomi clan or he is from Monzar clan that he has adopted at a later stage. And the joint DB's court, which involves both the tribes. The Bashis from both the tribes are involved here. They came to a finding that Ihoto is actually from Yaptomi clan and not from Monzar clan. So this GB post now belonged, initially also it belonged to the Simis. Ihoto was a Simi who adopted the Sanctum identity. And because he lost this case, he resigned from the GB's post. Where's the definition? Your Lordship, I will show you, Lordship. On page 37, Your Lordship. Annexure 5, page 37. May I read, Your Lordship? To the Additional Deputy Commissioner Sejung Nagaland, resignation from GB Yangzitong village. In inviting to the subject cited above, the undersigned have the honor that as per Sejung DB's court case pronouncement on 7 January 2021 and acceptance done by me on 12 January 2021, I do hereby tender my resignation Yangzitong village with effect from 12 January 2021. So, Your Lordship, when the decision was given that he is actually from the Simi clan, and he tried to question this, but he was not successful. So that is why, since the GBship is, the kingship is hereditary, and he has denounced the identity that made him the chieftainship of the tribe, that's why he has resigned. Now, when all these chapters are closed, shockingly, the state is relying on the decision taken by few people in the, not even the whole village, but few interested people with ulterior motive within the same village. The decision they are taking that he cannot be a GB because he is a Sanctum, but he has adopted a Simi identity. Now that decision is already taken by a higher authority involving two subdivisions of two different tribes. And the state is relying on the document in their affidavit to place weightage on a document which is redundant and not acceptable in the eye of law. That's why I was trying to show Your Lordship, to prove that, Your Lordship. Now, in this case, the village council has taken a decision recommending the name of the present petitioner for appointment to the post of GB, which was left vacant by Ihoto, who has accepted the other identity. And they are still contesting that he is a Sanctum. That's why they cannot recommend him. Whether that is acceptable in the eye of law, when a higher authority involving two tribes have already come to a decision that it was Ihoto who denounced the identity of Simi. If not, Hoheto, who is from Ihoto's bloodline, he's a Simi. That is already a decided issue. The other issue that they are raising is that he is found wanting in terms of moral turpitude and issues relating to that, because somebody fired blank shots in the village. He's not even the one who shot the fires. Even the persons who said they fired the shots, they were acquitted by the court. Now, when all these issues are settled, what is binding the state respondents, or what issue is there in the minds of the state from taking action when the village has already taken a decision as per the procedure that all of them are signatories, and they went back to question their own decision, which amounts to questioning a judicial decision, instead of going up before the appropriate authority, they themselves sitting over their own decision. How can a state turn blind eye to all these issues which is happening right under its nose? Then where will the rule of law be? One issue is the appointment of the present petitioner. The other issue is, where is the rule of law in Sejung subdivision? There will be lawlessness, there will be anarchy in the society if the state does not take hold of its own responsibility in the way it's supposed to function, Your Lordship. That is the saddest part. And that's why the argument which I have placed before Your Lordship, it's actually very childish even to be going through these documents, which has no meaning at all. but still the state is binding itself, bound by the decision which is taken by an unknown authority. And that's how the appointment is being kept pending till today. Your Lordship, unless a reply is required, I may be allowed to place one or two decisions, and then if my learned senior colleagues submit after that, I'll see. But Your Lordship, the decisions. My Lord, 2019 3 GLT 858. Your Lordship, I'm relying on para 4, 8, and 10. This is to do with the GB ship, the appointment of GBs. May I read, my Lord? Para 4. May I read, my Lord? Para 4. The learned Advocate General of the state, who was requested by the court to assist in the matter, in the course of several hearings of the case, had placed an initial report of the Chief Secretary, which is to the effect that the office of the Chief and Gaunbora in Sema tribe is essentially the same, though as a matter of practice, the Chief is known as Akakau. On behalf of the Chief Secretary, since, Your Lordship, I'm relying on this judgment because my client is from the Simi tribe, yes, which was earlier known as Sema. My Lord, Your Lordship. On behalf of the Chief Secretary, a report dated 4/11/2006, submitted by the President of the Western Simi, Kakami Hoho, was also submitted to the effect that in the Sema tribe, a chief is also known as Gaunbura. In the said report, it has been stated that the fundamental distinction between the chief Gaunbura of a Sema village and the similar office in other tribes is that insofar as Sema villages are concerned, the chiefs or Gaunburas are not selected or elected by the people, but are the descendants of the chiefs. Descendants of the chief, Gaunburas, who rule over the village on hereditary basis. In the said report, it also has been stated that the above customary practice has been in vogue amongst the Seminagas till date and since time immemorial, and further that though chiefs, Gaunburas receive their appointment orders from the government, such appointment orders are in reality recognition of existing status of the chiefs/Gaunbura. In compliance with the court's order dated 15/2/2007, the Chief Secretary has also filed an affidavit dated 25th July 2007, enclosing a report dated 12/7/2007, issued by the President of the Simi Hoho, Zineboto, which is the apex body of the Sema tribes in Nagaland. The Chief Secretary in the affidavit has enclosed the view expressed by the said body in the report dated 12/7/2007, which is to the following effect. The chieftainship in Simi society is hereditary by traditional customary practice, even long before the British regime in the then Naga Hills district of Assam. In other words, only the sons and grandsons of the village founder are solely entitled to inherit the chieftainship Akakau. No new assistant GB can be appointed in any way without the consent or recommendation of the village founder and his heirs. In recognition of their position, chiefs are given red blanket by then British government, which is still in force. The GBs of the village still wear red blankets, Your Lordship. Otherwise, chiefs had been there in their own traditional shawl in those days. Then, Your Lordship, the para 8, I take Your Lordship to para 8. We have given our anxious consideration to the above aspect of the case projected by the respondent number 3 and 4. The contention as noticed above was not an issue at any stage of the proceedings prior to the present writ petition. The same has been raised by the respondent number 3 and 4 for the first time in the present writ petition, wherein the order dated 27/7/96 passed by the learned ADC Judicial Zineboto holding the office of the Gaunbura not to be hereditary has been assailed by the writ petitioners. However, for reasons which are obvious, we have not thought it proper to preempt the challenge made on the aforesaid score, and instead we have deemed it appropriate to consider the said question on its merits. Then para 10, Your Lordship. In the light of the above discussion, we feel justified in negating the challenge founded on the touchstone of the equality clause under the Constitution. We therefore declare that amongst the Sema Nagas, the office of the chief and Gaunpura is the one and same, and the said office is a hereditary one. We consequently allow the writ petition and set aside order so and so. So, Your Lordship, here this is to do with a hereditary inheriting the right of kingship. Now, since Ihoto denounced his identity as a Simi, he has resigned from the post, and that is a traditional hereditary chief post. The few GBs who had earlier endorsed the name of the petitioner and then took on some flimsy grounds, some excuse, they are trying to run away from by withdrawing their signature. But number one, whether it is permissible for them to withdraw when it amounts to a judicial decision in the first place. The excuses, the two other excuses that they raised. One is that firing incident took place. No, that firing incident has nothing to do with the present petitioner. And even those who were involved also, they are already acquitted by the learned trial court below. Then the other issue is that that he is a sanctum. So he cannot, since he is a sanctum, but he denounced the sanctum identity, he cannot become the GB. That issue is already decided by a higher authority. So, my lord, even without repeating that, my lord is fully aware of that. Now, my lord, on the question of approbate and doctrine of approbation and reprobation. Now, these people, after being a party to a judicial decision where they have also appended, they were part of the same decision, can they turn around now and question the same judicial decision? So, Your Lordship, 2011 5 SCC, page 435, my lord. I'm relying on para 11 and 12. May I read, my lord? Para 11 and 12. In RN Gosain versus Yashpal Dheer, this court observed as under 10, law does not permit a person to both approbate and reprobate. This principle is based on the doctrine of election, which postulates that no party can accept and reject the same instrument, and that a person cannot say at one time that the transaction is valid and thereby obtain some advantage to which he could only be entitled on the footing that it is valid, and then turn around and say it is void for the purpose of securing some other advantage. Then 12, the doctrine of election is based on a rule of estoppel, the principle that one cannot appropriate and reprobate inheres in it. The doctrine of estoppel by election is one of the species of estoppels in pious or equitable estoppel, which is a rule in equity. By that law, a person may be precluded by his actions or conduct or silence, and this is very important, Your Lordship, or silence, not challenging the judicial decisions also, Your Lordship, or silence when it is his duty to speak from asserting a right when he otherwise would have had. Taking inconsistent pleas by a party makes its conduct far from satisfactory. Further, the parties should not blow hot and cold by taking inconsistent stands and prolonged proceedings unnecessarily. My lord, another one is a 2026 SCC, page 387. You have that copy? 2026 SCC, 387, para 26 and 27. May I read, my lord? It is also not disputed that the plaintiff and defendants 1 to 3 herein filed suit for eviction of an occupant in which he claimed that the property had been bequeathed to him by Hariram. According to the defendants, the plaintiff, having accepted the will of Hariram and taking benefit of the same, cannot turn around and urge that he is not valid and urge that the will is not valid and that the entire property is a joint family property. Plaintiff and defendants 1 to 3 by accepting the bequest under the will elected to accept the will. It is tried law that a party cannot be permitted to approbate and reprobate at the same time. This principle is based on the principle of doctrine of election. In respect of wills, this doctrine has been held to mean that a person who takes benefit of a portion of a will cannot challenge the remaining portion of the will. My lord, 27, para 27. The doctrine of election is a facet of law of estoppel. A party cannot blow hot and cold at the same time. Any party which takes advantage of any instrument must accept that it is mentioned in the said document. It would be opposite to refer to the treatise, equity, lectures, etc. By F.W. Maitland, Equity, a course of lecture by F.W. Maitland, Cambridge University, 1947, wherein the learned author succinctly described the principle of election in the following terms. The doctrine of election may be thus stated, that he who accepts a benefit under a deed or will or other instrument must adopt the whole content of that instrument, must conform to all its provisions and renounce all rights that are inconsistent with it. My lord, they have not challenged the decision of the joint DBs, which had ruled that Ihoto, whose post is now under contest, Your Lordship, is from a Simi clan. They have not challenged the decision anywhere before any platform. It has attained finality. Now can they turn around saying that the present petitioner Hukhatu is from Sanctum tribe or Sanctum clan? Can they say that now? They cannot. Unfortunately, the state is relying on, even within the same village, only few Sanctum GBs are coming with their own decision. The state is relying on that to strengthen their argument, which is unfortunate. So, Your Lordship, that is my humble submission.
Yeah. It is already ready. They already sent the link or what? 10 minutes is left. No? I'll hear up to 12. I'll hear up to 12. And then I can read them because I have a VC from Gauhati, in fact.
Okay.
Let's proceed.
Then after lunch, then if your lordship is
Not
busy,
after lunch. VC will take hardly 10 minutes.
Okay.
10, 15 minutes. Then again I'll come and pick.
okay. So,
Before lunch break only, it may be, you may be finished it up, I think.
yeah, actually, I have very, very forceful, substantial, but I'm brief objection only submission. My submission will be.
Okay, now this, okay, you can start up to 12. I'm going to hear.
Okay.
Till
but,
12.
Till 12. Then
Till
we'll be
12, I'm
sitting
going
here,
to
Your
hear.
Lordship. It's only a few minutes. We'll wait for Your Lordship.
Then after 12, we can resume.
It's not connected, I think, na? Till now.
They may be coming now.
Because I have given time at 12, so it's not connected, I think. We have a principal
Okay.
PC from principal C. It will take 10-15 minutes. Then
Okay.
again, up to
Then
12,
we
I
can
can hear you.
maybe
Up to 12, I
12,
can,
10, 12, 15, we can start. So we'll just be here. It's okay.
up to 12, I can hear you.
My Lord. Your
If
Lordship.
you, if you want to submit, I can hear you up to 12. Then only I'll resume this one.
My Lord.
Till 12, I'll hear you. Then after
But,
10-15 minutes.
Oh.
No,
Only
I get 10-15 minutes. It will be a break, you say.
Okay, after
Because if 10-15 minutes, it will take 110-15 minutes. The principal seat matter. Then again, I'll.
wait,
You
wait,
can submit,
10
you
minutes.
can proceed your hearing till 12
okay,
and then again.
Yeah, yeah,
12:15 12:15 or 12:20, I'll be here.
okay. Your lordship here. This village, unlike other village in the state of Nagaland, this village consists of two tribes, two ethnic tribes. So while answering any issue arising out of this petition, it has to be based and it has to be, the mind has to apply basing on these two ethnic group consisting of composed one village. And number two, my duty, my subject is to maintain law and order in the state of Nagaland. So this has to be, it has to be governed throughout the issues. Again, lordship here, the petitioner, the submission of the petitioner counsel, if it was in the form of civil, it would have a very interesting suit because all the facts, issues is involved in the civil manner. But anyway, he has come under 226 of the Constitution of India, and while filing this petition under 226, the petitioner has submitted only one solitary prayer, that is, direct the state respondent to appoint petitioner as the GB of Jansetong village with immediate effect. That is only the sole prayer of the petitioner. So in order to meet this, Your Lordship, I may be allowed to take to
Their
the,
only prayer used for the immediate appointment of the GB.
yes, GP. That is that only prayer they have. And in order to meet that, since I'm the custodian and I'm the authority, we have issued, you kindly see the annexure B and C, my additional affidavit. Form replacement of GB, annexure B. Additional affidavit, page number 9, annexure B.
Additional or affidavit?
Additional affidavit. Additional affidavit. File on 8 August 2024, annexure B. Additional affidavit,
Which additional?
19 August.
Here is no lectures are there.
It is filed on 9/8/2024. Heading is not given that there is an additional affidavit, but dated is 19 August.
No, we have received one affidavit here.
Yeah, we have filed 2 affidavits. One was filed on 5th April 2024, and by the order dated 7 June 2024, we filed 1 affidavit in the form of additional affidavit, which was filed on.
Have now here.
We
In
have,
every affidavit filed by you on April, there are the annexures of B and C are there available.
yeah, but subsequently by the order dated 7 June 2024, we have filed 1 affidavit on 19 August 2024.
19th of August, no?
19 August 2024. It was in compliance to the order.
9th of August or 19th?
9, 9,
Ah,
Your
yes,
Worship,
19th.
9. Sorry. Annexure B. Page number 9. Here,
Yes, yes.
annexure B, form for replacement of GB. So there we have given a serial number 1 to 14. So Your Lordship, if you go by the serial number 12 of that form number, serial number 12, was there a general consensus of the years by village, scale, colony? That is 1, general consensus. And D, date of general consensus. 14 is meeting minutes or memorandum of the general consensus attached. So that is 1. Again, annexure C, that is page 11 to my additional affidavit. There in the second portion of this form, checklist, replacement appointment of GP, serial number 8. Serial number 8 is meeting minutes of the general consensus on selection of the proposed GP by village council with attendance sheet in original. So in order to answer the prayer of the petitioner, we have issued this. And why these 2 formats are used by us, time and again, appointment of the Kampura GB, so many dispute arises in the state of Nagaland and Bharti, they are taking so much pain approaching to the court. So in order to maintain the peaceful law and order in the state and in the village, even in the appointment of the Kampura, we have issued this form. So whether the petitioner has complied or not, this as a question put to the petitioner. Again, my submission.
They have to fill up the forms.
Yes, yes. And it is not adverse to the petitioner. We want to see that appointment of GP is consensus in the village. And there is no law and order, there is no creation of multiple litigation taxing on the innocent villagers, for which purpose we have issuing this form. So the petitioner could not file this, and all the submission of the petitioner, it is full of substantial question of facts. And we cannot say anything about on the submission of the petitioner because it's all about the facts. But my question in the present matter is whether
So till date, they have not filled up the form or not?
no,
submitted
not as submitted. And basing on that, this village consists of two ethnic group. That's why we just want to it is not a dispute. It is the dispute within the petitioner village. So you softwares will appoint. That is our step. And again, I keep on repeat that it consists of two ethnic group. We want to see that just for the appointment of one Kambura, two ethnic clash come out in the state of Nagaland. So that is the ultimate. But the thing is here in the present matter is petitioner has not completed his job. Then how the infringement comes? The infringement of fundamental rights of the petitioner, how it comes? So it has to be done by the petitioner so that we can appoint a Kambura. And now whatever decision referred by learned colleagues, this is all that the GLD it is about the Sumi village, the particular village it applied to that. And again, the subsequent two references, it is not applied. It is within themselves, not with us. It is within those communities in the village only. So the decision given by the honorable court and those two matters, it is within the petitioner and in the village only, not with us. So it is not applicable at all. But the thing is, petitioner has not done, and no action was, see, the Article 226 has to be applied. The writ has to be issued to the authority as and when there is a infringement of fundamental rights of the petitioner only. So here, my submission is that they have not yet completed their job and they're just pushing us. They're not pushing us. And now, when it normally, even though it is consists of the two community, but normally it has to be, since whether it's a two community or three community, but it comes under the umbrella of Jansidong Village Council. So our target is village council in the village, there should be a consensus in order to appointment of the Kambura and Mitimenes is also consensus. So irrespective of the composition, then it's already 12. Let me continue.
Yes, yes.
Okay.
It's ready on. Okay, just for 10 minutes.
Lordship.
There's also, there's one incident. Otherwise, when people know, what's been like in on my list to see that. It is not a public, it is the administration who is doing to take the role of a teacher, so especially in some good officers, resisting place, within the council, like, and I'm going to land into the whole, into another. And then I think we'll Jason one late night, and then I will go. That I'm in Chalo or at the end of the day, I don't think I was able to. Thank you. Thank you. Nakalim bar, holding to the meeting game. We have with our rector. To last month. I'm with him and it when I'm out. Vision. They got it down, but we did not be on it. Under the whole thing, they got it.
Yes.
Worship, I have another 2-3 minutes submission
Okay,
only.
no, right.
Now, as pointed out, the learned counsel of the petitioner, the kinship, the Kampuras, GBs, among the Sima, it is, we have nothing to do with this. As per the custom, the GB is inheritatory. But the question here is, it is not a predominant village of the Sumis. It has consists of 2 tribes, Santam and Sumi. So there also now among the Sima, the post of GP is inheritatory. But when it comes to other tribe, they are mixing with the other tribes and they are governed by the Yansidong Village Council. So this has to be given in mind. And the thing is, among the hereditaryship of the Kampura, about the Semu tribe, we have nothing to
But
say.
his submission is most probably that the earlier Gauhati,
Yes,
he was basically, he belonged to Simi tribe.
yes,
But subsequently he renounced the tribe and then he was
Yes.
Santham.
yeah,
But the question is that this petitioner is of that heredity, most probably. That
Yes.
was his submission.
yeah,
So
that is
now
the
you are
subject.
saying that because there are 2 tribes, it's not the
Yes.
case that all the Simis will inherit, but
Yes.
Sankam has also the right.
Yes, now the thing is, whether it's a conversion of one tribe to another, that is their subject. We have nothing to say. And within the village only, within the petitioners only. But my submission before the Honorable Court is, in order to avoid law and order, and in order to avoid any untoward situation. So we have given that that form in my additional affidavit. Annexure B and C, it has to be complied by the parties. So that is my only submission, and this why we have joggot, why we are using these two format. We have a lot of experience. For appointment of one Kampura, so many litigation come up and disunity create among the villages. So in order to avoid this disunity and in order to avoid those financial loss and litigation, we have joggot this form. So that lead the Kampura appointment should be come out from one village council amicably and in one consensusly, that will appoint. We cannot say that not to appoint. So those are my submission. And whatever this, the facts has, again, submitted by the petitioner, that is within terms of, we have nothing to do with the fact of the case and whether is that there was means the matter was heard in different forum and different authorities, that is not a matter. This is within terms of only. If it were a suit, then we could have framed substantial issues. But since it is come in the form of writ under 226, so the proximity, whether the petitioner's right was infringed by the act of the state, the proximities, I find the proximity is too remote here. So petition under 226, the petitioner may not get the relief under this. But if it is filed in the form of civil matters, then definitely they can highlight the entire fact. So my submission is, since the petitioner could not establish the infringement of the right under 226, this petition cannot be maintained. So that is my humble submission before your lordship.
One more thing I want to ask you. Suppose you have provided some forms
Yes,
that has to be filled up by the candidate, whoever for the.
yeah, by
conference
the
and
yeah,
all.
consensus.
Yes. Now, question is that, is there any, no dispute was there? That
Yes.
who was to be counted from this clan or other this tribe? So there are some dispute, most probably
Yes.
still dispute, and particularly the petitioner, whether he has some criminal antecedents or whether he has related with that fire incident. These are also the matters
Yes.
which the council had already submitted. But the question is this, if those the forms were filled up by the petitioner or
Yes.
the candidate, whoever, then as a state, you don't have any objection in appointing those, or
No, it be filed consensusly along with the meeting minus with attendance sheet. No, we don't have any objection. Why we issue these two forms? The sole target is to maintain law and order and to avoid litigation expenditure and all among the villagers. Because we have came across so many disputes and so many situations. And it is my prime duty to maintain law and order in the state of Nagaland. So that's the only purpose. Otherwise, if the petitioner, whoever may be, if they file the form, submitted to fill a form, then the state has to issue the appointment only.
yes.
Lord, my learned senior colleague has given a very short submission, so I don't have to give a long reply. The one question is whether the form was filled up or not. I will take your lordship there. It's filled up. Whether meeting minutes of the village council is there or not, it is there annexed in the writ petition itself, your lordship. May I first take your lordship, which I have already read, the village council meeting, your lordship. A decision was taken.
Village council meeting is there.
Yes,
It's okay,
and
but the
all of them
form
are
which you got in the
signatories.
form, where is
Then the form is at page 43, your lordship.
your petition, writ petition,
Yes, of the writ petition, page 43.
43.
Page 43, 43, annexure 8.1. Your lordship, the village took a consensus decision that is involving some who wanted to retract at a later stage with unnecessary excuses, where there is already a judicial decision regarding the points of dispute they were trying to raise. So it is not a subject matter of civil. Also, my lord has fully catch hold of the situation. So, my lord, when all these conditions that is to be fulfilled has been done, the appointment being kept pending for 4 years.
But there is one issue.
What?
Though the village council meeting was there.
Yes, your
They
lordship.
have there all the signatories are were there.
Yes.
After that meeting only, you have filed the form. The form was filled up at when?
No, form is to be submitted along with the village meeting minutes, which is
Village
at
meeting
page 40.
minutes, yes, village meeting minutes, along with the village meeting minutes, you have submitted this form.
Yes, it was submitted and it is accepted
But
by the,
thereafter, most probably the dispute arose.
yes, after that,
That's
one,
what I'm saying now.
that is why, your lordship, after that, a firing incident involving some other people took place, where that was taken as one of the excuse to withdraw the signature. The other excuse taken is that He's-
That you have already
yes.
submitted.
Yes, your lordship. So, my lord, and all these are settled issues. Issues which are
Now,
already
see,
settled.
From
my
the
lord.
state government side, they only reply only their plea is that with a consensus decision, if you file the, or if you fill up the form and that is submitted.
Yes, your
the
lordship.
government has no,
It was done.
objection.
It was done, my lord.
It was done means it was done earlier.
Yes,
but
your lordship.
Subsequently,
Subsequently, yes.
the signatories, some of the signatories had
Withdrawn.
withdrawn their signature.
No, but
and
can
all.
they
So
withdraw
now
from
this
a judicial decision, your lordship?
It's not existing at present. That position is not existing at present, wherein there was a consensus decision and the village meeting was there and you have annexed the minutes of the meeting along with the form.
that is for
But
your
the-
lordship.
Now the scenario is a bit different because after the objection raised by the student. So now
No.
what is your position now?
No, that is why, your lordship. Two issues came up. One is the firing incident, which they tried to implicate the petitioner. But he was not even booked because he is not responsible for the firing. And those responsible for the firing also, they were
Those
acquitted
facts
by
cannot
the.
be decided by under
No,
the
that is why, your lordship.
How can we decide all this?
No, that is already a decided issue which they raised. It's a decided issue. The persons who were involved in the firing also, which has got nothing to do with the petitioner, it's solved. Number two, the issue of his
Then only
identity
we
as a
can take the
sanctum.
Direction, then you again, there has to be one meeting here, the amicable decision has to be there, and then only you can file family fill up. Because.
Your lordship,
after-
can
after this
the
pro-
question of whether the dispute, question of dispute that they raised, your lordship. Now the state is trying to break up the village, my lord, I will say that. Because now the issue that has been raised, number one, that they tried to implicate him in the firing incident because they had some ulterior motive. That is already solved. They tried to say that he's a sanctum. That issue is already taken up by the two customary courts, your lordship.
Yes.
And when all those issues are settled, my lord, your lordship, where is the question of submitting the form twice when knowing fully that these people, the kingship of a Simi tribe, the chieftainship, the Ganburaship, is hereditary. So in 2019 also, I have filed an affidavit also to that effect, your lordship, an additional affidavit. 2019 also, when one Sanctum GB was to be appointed. In other villages, we don't know, but in this village, in the Yangzitong village, Sanctum also, they are also hereditary. The chieftainship is hereditary. We have not objected. And they proceeded even without our signature, without without the village council decision taken by both the tribes. We allowed them to just go ahead. Now, in our case, why is the state trying to be biased in this case, your lordship?
In that case, what do you do? Want to submit any instructions from your department concept? But the question is that he raised those issues. The form was earlier filled up along
Yes.
with the decision of
Yes.
the council, and so that was it. But the objection was there. Some of the signatories had withdrawn
Yes.
their signatures after that incident of the fire and all. And that apart, the question also arose as to whether he still semi or a sanctum or whatever. So those decision has already actually submitted that the firing incident had the person got arrested. Subsequently, he was acquitted also. So the matter is there is no more. And now signatories who withdrawn their signatures and also in that case, they are saying that this matter is still there. So now what to say? Do you-
So
can
your
you-
lordship here, it is very clear.
Because
it-
otherwise it will be
yes,
problematic for us
Yes,
also.
withdrawal, I mean, Annex A in my earlier affidavit is a withdrawal.
Yes.
So in that case, my stand is very clear. So the moment are submitted by the council, they have submitted that form as required by the government. And subsequently, another group came up and it has brought in a notice of the state that they have withdrawn their signature. So in that case, one has to see the stand of the state also. If any consequences come up, it is my duty. So I have to say, and I should be very watchful. And now that let us not talk about Sanctum or Sumi. Let us not talk. It is governed by the one village council, Yangzitong village council. So we focus on that, but we give a extra caution because it consists of two tribes, two ethnic tribes. Otherwise, whatever grievances, whether it's from the petitioner or by the other tribe, then we have to see it is our duty. So long as the complaint is there, the withdrawal is there, then how to comply, how to accept that form B and C has been duly filled up. We cannot take it granted that it is already flagged. So it is the dispute is among themselves only. But now the petitioner, they are just again hitting on the state. Otherwise, they have not completed their job. They have not done.
How is that possible, Your Lordship? That
Yes.
submission now should not be
See,
accepted
because
after
you
I
see,
my
you
clarification.
see, even though it consists of two community, whether it's a Santam or other tribe, we have to see, we have to watch from the village council, Yansitong village council. So we don't touch, we don't go against
Mr.
any of the
Ahmad,
custom.
can we secure this village council meeting where there were some signatories where all the signatories put their signature? There
Yes,
was a
Your Lord.
consistent decision.
My lord.
But that is not in existence now.
No,
Now,
that
these
is
are the
still,
facts-
that is
no, no,
still on
but
the
these
table
are
of the state
facts to be
respondents,
decided
my
as
lord.
to whether they want to withdraw their signature or again they want to, these are the other, whether legal illegality or the other issues.
lord,
But now under,
My lord, on the question of law, if my lord may kindly allow me. Now, this decision of the village council, it is a judicial decision. Can you appropriate and reprobate? That is why I have relied on
Yeah,
some
relies
judgments
on
also, Your Lordship. Can you say that the instrument is good today and tomorrow it is bad? It is a judicial decision. The village council itself is a court. It is a judicial decision. Can you just withdraw at your own whims and fancies at your sweet given point of time when you feel today is good, tomorrow the same instrument is bad? Now, the two issues that they raised is already a decided issue. The one issue is the firing incident, which does not involve the petitioner. And even those booked were also acquitted. Number two is the identity of the present petitioner, Your Lordship. It is decided by the Joint DB's Code of Arnato and Sechung involving both the tribes, DBs. So, my lord, on the decided issue, when the law and the facts are clear and there is no it cannot be disputed because it is a judicial decision. Now, when these things are clear, what is the problem with the state to go ahead with the appointment when no dispute, no more, disputed questions raised, no more survives? So the only issue is now to appoint the petitioner, Your Lordship. And my lord, even the learned AG, my senior colleague, also will have to be very careful in this kind of issues because the state must put its hands down sometimes, at times, when it is required for law and order, for people to respect the rule of law. The state has to be firm. If not, it is the state respondents who are trying to break up this village because it is of two tribes. And my lord, if we have to see the overall strength of the tribe and it becomes a tribal issue, Your Lordship, the Simi tribe is definitely a much stronger tribe, but that is not an issue here. And here it is the state who is trying to create a rift in the village. And this village may be broken up into two villages, Your Lordship, where tribal issues will come up again. State must learn how to put its hands down at the right moments where there is no dispute, Your Lordship, in terms of law. And I'm happy that my learned senior colleague also did not rely on some of the documents in his affidavit, which are actually on decided issues. So that it is my humble prayer that my Lord will direct the state to proceed with the appointment because the criteria laid down is fully fulfilled, Your Lordship. And my learned senior colleague was earlier submitting that it is not in the petition, it is in the petition itself. Now he cannot turn around his submission also, Your Lordship.
My Lordship, our duty is very simple. To maintain a law and order, and so long as the withdrawal of the signature is there. So if I act upon, then another party will come forward. It may create a law and order and it seems
Oh,
to
law
be
and
a
order problem, if it is
And
created, Your Lordship,
now-
the other
now
tribe will have no
this-
stand if law and
this-
order
this
problem is
matter,
created.
It consists of substantial question of facts. So petitioner has an alternative remedy to redress his grievances also. That is my humble submission.
copies from here. Otherwise, it will be problematic for me to carry this box. Yes, read. Okay, order is so. Form 17.
For hearing item numbers 18 and 19.
Flush, Your Lordship.
Yes.
Yes, Lordship. Lordship, here in this case,
No, I don't know. In the morning hours.
yes, yes,
One counsel came
yes,
and
yes.
he told me that the earlier counsel has already withdrawn from this case, and now he is appointed in this case, and now he going to file the Bakartama and this thing. So he required, I think we have given
27 days.
27 days.
Yes, yes. We have
in that
actually,
way he
on
told me
previous
that
date, we have not
but that
withdrawn.
was, pardon?
We have not withdrawn. Only today we were going to
Then
withdraw.
how
Yes,
he
Your
is
Lordship.
submitting all this?
Yes, he
That
was,
could not be in fact.
yes, he was also under the instructions of some seniors. So,
Yes, under
Yes.
instructions of some senior.
yes.
So you had not withdrawn yourself.
No, no, only today we were going to withdraw. So that's why. So I would
But
like
the
to
submission was
submit
that way only.
with this
That should
NOC.
not be in fact.
Yes,
Yes. And before making such kind of submission, at least you should be informed
yes, yes.
that if you're not going to there and then we are going to withdraw and all that,
Oh.
their kind of submission should be there in fact.
Yes. They have not told
Without
us anything.
submitting all this.
What I've submitted is the NOC from the leading counsel from of the previous counsel, Your Lordship.
Pardon?
What I've just submitted is the NOC, no objection.
Yes,
Yes,
you have
yes.
already withdrawn, you have no objection.
Yes, yes.
Okay.
Yes. Ladyship, however, here the applicants are not cooperating. They were neither cooperating with the investigation agencies, nor respecting the direction of this court. 2 occasions from direction has already been given by this honorable court to appear before the IO, but in both occasions,
Yeah, not
they have never. So I think they should not take the judicial order as for right. I think they should be outrightly rejected, because even if another counsel comes, it's not going to make any difference. Before,
Definitely we make your submission on 27th, we'll definitely advise you. Status report is with you.
yes, yes.
Okay then. Who took the dictation earlier?
The name of the advocate.
No, not advocate. The secretary?
Oh, yeah, we have actually informed her also. Yes, yes,
yes.
earlier in the morning.
দুটা লগাই দিব
Lordship, I have a small prayer, Lordship, in
Your good name?
Medovero. Lordship, the name of all the previous counsel may be deleted from the cost list, Your Lordship.
You Medovero, na?
Yes, Lordship. Yard, Jury, Fosecofote, Chupanangkam, and Medovero may be deleted from the cost list, Lordship.
দুইটাতে একই order হবো নিছে না? By Mr. Swenson Medovero, the counsel for the petition, and submitted that he along with all the other counsels who were earlier appearing on behalf of the petition wants to withdraw their name from the Wakalatama, and they do not have any objection if some other counsel is engaged by the petitioner. In that regard, he already submitted rূপান্তরিত করে these two. তাৰপিছত ইজন counsel যিজন আছিলে এজন counsel কথা ক'ব Hart so-and-so. He submitted that he had appeared before this court on behalf of so-and-so, but senior counsel assistant second so-and-so, and submitted that Wakalatama has been filed today and need some time to make submission in this case. So your submission we record or what to do now?
It may be recorded, or I leave it to my lady. Because it's just a matter of
No,
2-3
we
days.
won't record it now. Today we won't record.
Okay.
Because on that day only you record
Okay,
your
okay,
submission, and
okay.
if there is no cooperation at all from the so-and-so, we'll see to it.
Okay,
The status reports you have, you furnish the status report
Okay.
before us, and we'll hear to it.
okay.
So today we are not going to,
Okay.
otherwise there may be a message to them only, that's why I'm not going to hear.
My lady, in the morning, we fix it for 27th.
Next 27 only we're going to fix. So, let's see matter hard PP hard করে দিব আর Mr. So-and-so at PP PP listed responding. Let the matter be listed on 27/5 so-and-so. Further, the SDA is directed to delete the name of all the councils earlier appeared on behalf of the petition from the cause list.
Oh, bless you.
Please.
Oh, bless you.
Now, before submitting this one, at least there should be one information to us, but that was not with
Yes.
us. We thought that there was already, you had a talk with the other side, that's what I thought. Now only I come to know that actually.
It's not.
And sometimes in what happens in principal seat one order was there from our registry, that if anyone pays for an adjournment or whatever, the other side should be informed in fact. But it happens sometimes we see that we have generally always asked that whether you have informed the other side. Yes, I say yes, we have taken the consent. And subsequently, the other council sometimes appears and say that they have not taken our consent and we are not aware that the date has already been given. So in that position, we also feel very, I think, no?
Yes, yes.
Because we need the cooperation of the both the parties, in fact. That's right. Okay.
Oh, bless you.
In the morning.
you.